with the today class, we'll be seeing about the IPR as well as the legal issues. Okay. So when you talk about the IPR, the intellectual property rights, so it's associated with the commercial value. Okay. So as well as goodwill associated with the inventions. So if you are creating, if you are inventing something, so the invention should be available to the public. Okay, so the invention should be useful to the public. Invention also will be protected by the law. Okay, so the invention should not be stealed by somebody else. Okay, uh, so you need to have the kind of uh, the preventions getting from the preventions to copying from you and others. Okay, so like the computer software, trademarks, designs, everything will come with the come under the IPR. Okay. So this IPR law using with the using the IPR law, so we are encouraging the innovations. Okay, so whatever the innovation is novelty brought by the applicant. Okay, so uh, those are making the such a wonderful the design aspects and all those things. Okay, so this design aspects, so the author will be spending so much of research work towards the particular work. Okay, so this IPR law will be encouraging the innovations as well as the, it will protect the author from the misuse of others. So whenever you're inventing something, so the invention is given based on the author the input. Okay, so based on the design methodology and all those things, so the author is given the authority. Okay, so if anybody is misuse nobody can misuse that design aspects and all those things. So from the author they have to get the permissions like that. Okay, so that is very very important. So the IPR law it's used to have the getting the protections for the author for their innovations and all that. Similarly, we have like a patent law. So you will be looking for the patent. So when you look for the patent, so uh, when you're looking for the your design aspects, so the innovations, you can look for the patent law. But the scientific theories or mathematical techniques, so this all cannot be taken for the patentable and all those things. Okay, so when you're looking for this, because the theory, the scientific theories, you can use that and you can innovate on your design aspects. Okay, so similarly, inventions against the public interest are also outside the scope of this act. Okay, so when you're why this is very important when you're looking for the kind of designing a system. Okay, so you need to look for the how your design can be protected. Okay, so how your design can be protected by the law, so that it will be useful. So a lot of focus is there in the when you are using the IPS and all those things. So we have like a few conditions. So when you look for the IPR, when you're looking for patenting your designs and all those things. So this conditions, a few conditions are there. So you need to produce the novelty. Okay, so your design should be novel one. Okay, the new one. So it's a kind of nobody used like that. You need to bring. Okay, so when you're bringing the novelty on your design, okay, so you need to ensure that it's not published anywhere, not used anywhere, so that you can bring your novelty here. Okay, so as well as, so we need to give the inventive steps. Okay, so we need to give the all the design elements and all those things, so we need to involve on that. So if it is published and not patent, can be taken here. So we can look for the kind of applications. So the industrial application, generalized way industrial application is given. So you can look for the, any industry, any industry. So applications you can make. So this patent will be given for the 20 years. It can be granted. So during this particular period, nobody cannot copy. Okay, so others cannot copy. So when you have this kind of uh, uh, protection for your design, so without asking you, so nobody cannot use that. So the author is ensured that so their design is protected by the law. Okay, so that is very very important when you're talking about the patent. Okay, so further, so when the patent is infringed on all those things, so when sometimes the innovations whatever you are making, so sometimes where the innovation is the product and the other person makes it, dispose it, or offers to dispose, sometimes they will use or imports the products and other things, so that's a patent is infringed. So invention process, sometimes the particular process can be used by the another persons, so they will be using, sometimes they will be disposing that particular methodology. So whenever they're getting this the process, so they will be sometimes they will use it, they will offer to dispose, they will look for the particular product. Okay, so from the imports and all those things, so uh, this all it comes into. Okay. So we need to avoid by provided by the considerable info on the design, so that uh, when you're filing the patent and all those things, so we need to avoid. Okay, so considerable info. Okay, so you need to avoid. Okay, so when you're filing so when you're looking for the new products. Okay, sure. So the new products when you're launching, so the new product should replace the old properties, because you're going to show the innovations on that. So the old properties, sometimes, so we'll look for the kind of replaces old ones and all those things. So the entire model can be replaced. So this all can be patent. Say example, when you're using the manual thing in the machinery equipment and other things, if you are making with the automated systems, so that can be taken as a innovations. Okay, if your equipment is working in the semi-automated, you are making the automated, so you are writing the coding and other things, that can be included in the hardware, so that can be, so like that. So when you look for this kind of information, so you need to understand old properties are replaced. Okay, so we'll be replacing with the new properties, new product, new hardware, like that. Okay, so that is the advantage. So this also can be ensure that so nobody others can copy. So the patents as well as the licensing. So we need to get the license for the manufacturers as well as the marketing. So for the patented product, so we have the detailed procedures. So when they are adapting for the manufacturing as well as the marketing of the particular product, so they need to get the license. So they will give you the exclusive license. So um, preventing any other persons, so including the licenses to sell the product within the particular area, so the territory we can say. So when you are assigning the licenses should be taken the selling the product only the within the particular region. Okay, so if they want to go for the other territory and other things, so we need to go for that exclusive license for the others. So this eliminate the competitions and all those things. So similarly, the patent owner also will be in trouble if the territory of the license is very wide and all those things. So you need to understand. So what is the product you are launching? So patent. How the product is manufacturing. So who is the authorized selling person? So to whom you are giving license and all those things. That is very, very important. So the patents and licensing is very, very important. So when you look for the the patent owner as well as the license. So we need to consider the few information. So the very important thing is NDA, so the non-disclosure agreement. Okay, so this non-disclosure agreement is very important. Uh, when you are visiting any hospital, uh, so you'll be giving the consent form like that. Okay, so like that. So why we are giving the consent form, the doctor also will be asking us to get the signature from the patients or person. So when they are practicing for the telemedicines, they will be getting the consent form. So we will be discussing about the consent form in the later stage. So now I want to include here, non-disclosure agreement is very important. So because we need to ensure the confidentiality, so we need to ensure the confidentiality of the licensure as well as the who is involved in that, how they involve that. Okay, so if they are collaborated with that, with the license and all those things, so how the entire durations they will be behaving. So what is the role, how before as well as during the event, as well as even after the termination of the license. So everything has to be taken care of. Yeah, okay, because one you are giving the license to the one authorized person. If the agreement for the 1 year or 2 years afterwards, if they are not, they can't go against to the patent owner or also. So the non-disclosure NDA agreement is very important. So that should be monitored. Okay, before, during, even after the termination of the license. So what they are doing exactly. Okay, so this need to get all the information about the licenses during the license period. So we need to look for the market conditions. If any change in the market conditions, so we need to look for that. Okay, similarly we can have like once the patent is registered, so we can have look for the patent enhancement, so the new patents. So we can have the updates of licenses and all those things we can. Okay. Similarly, when you're looking for the related to the intellectual property, so we have access to the other registers. We have access to the other registers, as well as unregistered designs and other things, trademarks, brand name. Even the brand name is very important. So nobody can copy. So we are seeing the several commercial companies and other things. So they use the brand names, so the trademarks. So this also can be registered. So nobody cannot copy there, the once if they register the trademarks and the brand names and all this. Okay, if they are copying, they will come in under the law. So they will be taken for the further inquiries and all this. And that is very good. Then we have the copyright law. So the this copyright law is one of the important thing. So we need to look for the telemedicine purpose as well as the and everywhere. So we need to look for the copyright law. So what is the purpose of this? Means we can have the legal protections to the authors, those who are publishing, so those who are giving. So without the author information, so without author consent, they should not publish anywhere. Okay, so say example, you have your content, so the your content is taken by other. Okay, so they are publishing somewhere, so that should not be in the condition. If they are publishing in that way, so the legally we can fight with them, then we can get the things to be done. Okay, so the proper inquiry and also. So we need to ensure that the legal protection to the authors and publishers for the period of time. So that to be there for their content. So when you are giving this assurance, the period of time, so nobody will be reproducing or taking the design aspects from them. So that should be avoided here. So that is a very important thing. So we need to ensure that the responsibility of author to prove the ownerships. So whatever the content design aspects they are giving when they are registering for the patent and all those. So the author should give their ownerships. Okay, so the content, whatever the material they are publishing, so they should prove that that is their own. Okay, so that is also it's very very important. Similarly, when they have authority to reproduce. Okay, so the same design can be reproduce, or we can load with the different the codings. We can have the run transmit as well as store the programs and all this. It can be taken. So that's owner can alter the programs and all this. The innovations can be included in that. Similarly, we can have them the production protecting the um, design. Okay, so that can be extended for the subsequent versions, different versions. If that's what I was saying, when they are writing the programming, so they can modify the programmings. So the and few modules can be modified. Okay, so that also can be considered here. So that can be extended. So the version one, version 1.1, 1.2, like that it will come. Okay, so um, whatever the programs they are modifying, so that can be considered as a new one. Okay, so this also can be included here for the computer. The legal issues, so when you have the legal issues, so we need to understand where you are going to perform the telemedicine. So the state regulation of telemedicine you need to adapt. So when you are performing the telemedicine, you need to comes under the state regulations. Okay, so that's what we were encouraging to sign the MOU and other things, so that the common protocols can be adopted, the procedures can be adopted for the sub-regulations. So the licensure as well as accreditation, then the reimbursement. Clinician reimbursement also is one of the important role in the telemedicine purpose. So when you look for the implementing the telemedicine, so you need to adopt the state regulations. Okay, so um, what are the issues that have common basis with the conventional medicines and all those things. So we need to identify so how this can be implemented. So what are the issues we will be having for specific to the telemedicines and all those things. So how when you are implementing the telemedicines, so you need to look for the uh, implementations of the particular state and other things. So you need to look for the local laws as well as the practice of medicine. So whatever the legal implementations. So this all you need to consider. Okay. So when you look for the implementing the telemedicine, the different states and other things, so the law and the legal issues. So we need to consider. So when you're looking for this law and the legal issues, this also could be the one of the barrier for the telemedicine practice and all this. Because the different the local bodies, then the different the state bodies will be there. So when you are implementing, so we need already the previous classes also I was saying. So we need to accommodate with the local bodies laws and all this. So that has to be local laws. So that has to be adapted here. So the different state will have the different laws sometimes. Okay, so that has to be taken. So when you are signing the memorandum of understanding and all those things, though this could be omitted. Okay, that can be implemented. So when you look for the telemedicine practice, so the claim of negligence also can be felt only if the patient and uh, doctor relationship can be established or not. So if it is established, then it's so sometimes we'll be having the less clear information. So if the relationship was established through the hotline or internet and other. So the patient doctor relationship, if it is established, then we can do it. So sometimes the patient will be in the very important thing is the patient will be in the different state. When they are looking for the telemedicine practice with the doctor in the different other states, other regions, and other things, how they will be looking for the claim. So from where they will be filing the claim to be filed and all this. This is all the another important area. So if they have the memorandum and all those things, then it will be easy. So so when if anything goes wrong, then the from where the patient will be taken the justice from their patient state or clinician state or somewhere else. So this all has to be considered. Okay. So when everything else comes into the memorandum. So when you're looking, so we can have the different trials with the more pro doctors laws and all those things. When you're looking for the legal issues, so in the telemedicine practice, so we need to look for the availability of witness, conveniences, expenses, the residence of the parties, and all those we need to. Okay. So when the patient is in different state, doctor is in the different state, so where the services they are looking. So when the service is offered, when they are offered the service to the patients, so the whether the service are provided across the borders, so when they are putting across the borders, so what kind of the benefits they will be getting. Similarly, we need to look for the different opportunities for the legal discord is more. So the different states, so which law will be applying there and all those things. So that is also we need to consider. So when you're looking for the across the borders. So one of the important thing is when you look for the telemedical malpractice, when the telemedical malpractice at sea. So when you look in this level, so if they say example, the patient is traveling in the ship. Okay, so they are in the ship, so they're at the sea level. Sea. Okay, so here. Where the claim, if any telemedical malpractice at sea is happening, so which country flag is flying on the ship may be able to claim on that. Okay, so that is also it's very very important. Sometimes if the ship is anchored within the territorial waters of the other nations and all those, so that also. So to overcome all those things, so they came with the G8 enabled projects. So G8 countries have signed the MOU already. I was saying, right. So the memorandum has to be signed. So when you're looking for this MOU, G8 countries, so they established the code of telemedical practice. So with the harmonious laws concerning security, confidentiality, standards of care. So how the care should be given. So the how the remunerations, IPR, everything. So this side. So that's what I was saying all the time. So if you're signing with the memorandum, even the small hospital is signing with the one of the multi-specialty hospital. So if they sign the MOU, so that will be easy for the practice. So similarly, we have the licensure as well as accreditation process. So when you are giving the licenses and other things, the person who's authorized to get the license, so person should have the relevant education. So they should undergo the proper training. So they should have reached after the training procedures and other things. So they should have reached the preset standards and other things. So then they'll be giving the license to practice. Okay. So when you're looking for the licenses, so uh, we'll be looking for the some kind of training programs and other things. So there is no standard for the how long the training should be and the content of the training are standards for the qualifying the doctors. So they'll be looking for the kind of in US. They'll be looking for the kind of additional exams should be taken for the to practice for the medical. They have to take some kind of additional exams USMLE. So before they appear for the licensing boards and also to get the license. So that's very very important thing is, so the healthcare they want to practice for that. So another important thing is the when you look for the telemedicine practice, the clinician reimbursement is also one of the important thing. So whether the the patient is consulting with the doctor, so clinicians, so how the reimbursement will take place, whether they will be paid directly by the patients, so whether they are going to get from their own money they are paying to the clinicians, are paid by the organization, agency, or insurance. Sometimes the group insurance will be there, and medical insurance will be there from the organizations. So from there they are paying. So this reimbursement will take place in to the clinician point of view, from the patient and or organization, agency, or insurance company. So similarly, whether the teleradiologist is reimbursed or not. So sometimes the non-video conferencing applications. Okay, so when you look for the non-video conferencing applications, example for the monitoring of the cardiac as well as fetal monitoring, so reimbursed. So all the areas will be covering, all the rural areas will be covered.